We are literally and figuratively speaking, sitting in the dark because of what happened at Eskom. What we could have done for education, for our health department. And then, there's a disaster. There was a disaster in KwaZulu-Natal. Don't know how long it's going to take that communities and just the province to get back up and running due to, the disaster, but the infrastructure that the money was just not used for what it was supposed to be used. So really, hopefully, by, taking these recommendations, and there's a burden on the president because he needs to now take the lead and make sure that there's accountability and that we are, let's take hands with
Two closing reports relates to the anonymous complaint versus the Limpopo Department of Health. It's the report number 6 of 2022-2023. We investigated allegations that the Provincial Department of Health in Limpopo irregularly appointed Mr. Mkhwebane to the position of the CEO at the WF Nobel Hospital in the province. After investigating whether the department irregularly shortlisted, interviewed, and appointed Mr. Mkhwebane to the position of the CEO, even though he allegedly did not meet the minimum requirements for the position, we found that the allegations were not substantiated and proceeded to close the matter because the appointment complied with the policies of the department. The other matter, Mahlangu versus PIC, this matter also was closed because the allegations were also not substantiated in that after investigating whether the PIC failed to conduct due diligence when providing funding to Daybreak through public funds, which the state-owned asset management company administered on behalf of GEPF, the UIF, and the CCF, and if so, whether the conduct constituted maladministration. So our findings were that this matter is unsubstantiated and we proceeded to close the matter. So the following reports have findings with adverse findings. Langalibalele and another versus David Kuiper, local municipality. This is an intervention letter. We investigated allegations of failure by David Kuiper, a local municipality in the Northern Cape, to compensate Ms. Tununu Maria Langalibalele and Mr. Mavela Mahlokomane for the loss of livestock in 2016. So the investigation followed two complaints lodged in November 2019 by Ms. Langalibalele and Mr. Mahlokomane. They alleged loss of livestock as a result of electrocution from a power line in the Onde Jah area on the 31st of July 2016. Ms. Langalibalele allegedly lost 2 goats, 2 sheep, and 1 cow, while Mr. Mahlokomane was alleged to have lost 4 pregnant goats. Mr. Langalibalele and Mr. Mahlokomane allegedly submitted claims to the municipality in August 2016. However, compensation for loss for livestock was not paid or remained outstanding. So they further alleged that the municipality compensated another person who had also lost livestock following the same electrocution incident. So we looked into the matter and our investigation was focusing on whether indeed the municipality failed to compensate them. So based on the information and especially the evidence before us, we concluded that indeed Ms. Langalibalele and Mr. Mahlokomane did approach the municipality to claim damages for the loss of their livestock, which constituted a liability against the municipality. Their claim was referred to the municipality's insurer, 11 months after the electrocution of the livestock. So the municipal manager at the time and the officials dealing with the claims for damages were responsible in terms of Section 63(1) of the Municipal Finance Management Act to properly manage the liability arising from the claims by both the complainants. So the municipality delayed to submit the complainant's claim to Aon, South Africa, in order for them to timeously consider and process the claim. So this undue delay by the municipality was improper and constituted maladministration. So the conduct of the municipality in paying the other affected person, Mr. Modise, 1,500 for the loss of livestock was improper, since the municipality failed to exercise any form of due diligence as envisaged in terms of Section 195 of the Constitution before taking the decision to compensate Mr. Modise for the loss of his livestock. So according to a lease agreement that Ms. Langalibalele signed with the municipality cannot be held liable against any loss of livestock suffered by the lessee. So having assessed all the evidence and information before us, we found that there was no policy or internal controls in place at the municipality to deal with the insurance claims against the municipality, except that the municipality had appointed insurers to deal with claims against it. Therefore, as an institution, we have the responsibility to recommend that the municipality needs to change that to avoid future maladministration or continuous maladministration. So we then recommended to the municipality to develop a policy which will deal with the issues of insurance claims, ensure that all officials of the municipality that are involved in the insurance claims process are properly trained accordingly, and report to council of the municipality on the implementation of this recommendation, and provide us with a report on the steps they've taken. So in this particular instance is an intervention, because we found that the claims were not substantiated because the lease which was signed by the complainants was exonerating the municipality. The next one is Nyathela versus the City of Johannesburg, report number 3 of 2022-2023. We investigated allegations of undue delay and maladministration with regard to irregular billing against the City of Johannesburg in Gauteng. So the investigation stemmed from a complaint by Mr. Freddie Nyathela, the president of the South African Roadies Association. It was launched in January 2019. Mr. Nyathela alleged that he had tried since 2005 to resolve SARA's billing account with the City of Johannesburg relating to water and electricity consumption, that he escalated the complaint in the previous matter to the previous mayor or executive mayor, Mr. Masondo, and that he suspected the existence of an ulterior motive to dispossess him of the ownership of the property from which SARA operates. He indicated that the property is situated in a prime location within Newtown district of Johannesburg, and went on to allege that there was an attempt by certain officials within or connected to the city to ensure that SARA closes down with the ownership of the property the organization operated from being taken from, in fact, where they were operating. So he allegedly also submitted an application for SARA to be considered as a non-profit organization, but that was not processed, and or City of Johannesburg ignored his application for such. According to Mr. Nyathela, a meeting was held between SARA and City of Johannesburg way back in 2011, whereby the City of Johannesburg undertook within 2 days of their meeting to resolve this complaint by fixing a water leakage and faulty electricity meter, both of which led to high costs. However, the City of Johannesburg officials did not attend to his complaint as agreed. In addition, Mr. Nyathela allegedly approached the Ombudsman of the City of Johannesburg in 2018 and lodged a complaint against the City of Johannesburg business entities, being Johannesburg Water and City Power, over alleged irregular billing for water and electricity consumption. He averred that the Ombudsman accepted his complaint and proceeded to investigate it. On the 20th of December 2018, he was provided with a response stating that Ombudsman's investigation revealed that he was being billed on estimates for power consumption and that it was for longer than the municipal bylaws allowed, but that the COJ has subsequently reversed the charges and billed on actual readings. So having analyzed the complaint, we decided to investigate the following 3 issues: whether the City of Johannesburg irregularly billed SARA for water and electricity consumption based on estimates and failed to adjust the account, whether reporting the complaint and seeking the intermediation of the Ombudsman was helpful to Mr. Nyathela, and whether the City of Johannesburg unduly delayed in submitting SARA's registration as a non-profit organization to the COJ's Revenue Shared Services Center, and that had an impact on billing of his account and thus prejudiced SARA. On the first issue, we found that indeed COJ irregularly billed Mr. Nyathela because those were estimations. And the second issue is that the City of Johannesburg provided a reconciled statement of account from the period 2009 until 2019 and failed to provide a statement of account from the date of occupation of the property, which is June 2005, as Mr. Nyathela has requested. So in so doing, the city has violated the Municipal Systems Act, which clearly states that the amount individual users pay for services should generally be in proportion to the use of that service. So the City of Johannesburg also contravened the Municipal Systems Act by not ensuring that where consumption for services had to be measured, Mr. Nyathela or SARA's consumption had to be measured using accurate and verifiable metering system. So the City of Johannesburg had a duty to inform Mr. Nyathela or SARA of the costs involved in the service provision, the reasons for the payment of service fees, and the manner in which the monies were raised from the service utilized. So on the second issue, we found that the Ombudsman did indeed fail to investigate Mr. Nyathela's complaint effectively. The COJ Council established that the Ombudsman for the sole purpose of being a neutral facilitator to provide confidential and impartial assistance in resolving grievances and complaints lodged with it against the City of Johannesburg. So the Ombudsman must investigate any alleged act or omission or any attempt by an employee serving in the municipality which contravenes the provisions of the Municipal Systems Act. So the Ombudsman had a duty to resolve all complaints received against the city and all its business entities in an unbiased manner and thoroughly scrutinize all complaints and allegations submitted to it. So the office had to interrogate the responses received from the City of Johannesburg and must not just act as a conduit of information from the City of Johannesburg and its entities. Therefore, in this instance, we also then advise the Ombudsman to analyze the information and make sure that they indeed come up with recommendations. On the third issue, we found that the City of Johannesburg indeed delayed in submitting SARA's registration as a non-profit organization to the city's Revenue Shared Services Center, which had an impact on the billing of SARA's account and thus prejudiced the organization. So to remedy this maladministration and improper conduct, we direct the acting city manager to do the following: ensure that SARA's account is brought up to date due to the fact that Mr. Nyathela made payments, but the City of Johannesburg cannot properly allocate same because, according to them, the check payments did not have any reference numbers to indicate the account number. Ensure that the City of Johannesburg staff dealing with directly or indirectly with consumers are retrained on the City of Johannesburg service delivery ethos, including the Batupili principles. Ensure that the City of Johannesburg staff are trained or retrained in the Consumer Protection Act, Municipal Finance Management Act, Municipal Systems Act, and the Promotion of Administrative Justice Act. Ensure that there is customer care training to all staff, including those employed at the Ombudsman's office. ensure that all business units within the City of Johannesburg embark on an internal stakeholder training to prevent continuous discord between the various business units, and ensure that steps are taken to redress the continuous estimation of consumer accounts. All of this must take place within 30 working days from date of this report. I must indicate that when we issue such reports, we've agreed with the various institutions so that they are informed of our remedial actions and they start preparing for implementation. The next report relates to Harman versus State Security Agency, which was we investigated the allegations of maladministration by State Security Agency relating to termination of service of Mrs. Harman and subsequent undue delay to properly reinstate her after her appeal was upheld by the Minister of State Security. So Ms. Harman was placed on suspension through a letter dated 30 April 2018, signed by the acting DG, Mr. Jafta. While still on suspension, Mr. Jafta dismissed her from employment through a letter dated 7 November 2019. Ms. Harman lodged an appeal against her dismissal with the Minister of State Security on 22 November 2019. And on the 27th of August 2020, the Minister finalized her appeal and sent a correspondence to Mr. Jafta, advising him that Ms. Harman's appeal had been upheld and that his decision had been overturned. Mr. Jafta was requested to action Ms. Human's reinstatement with immediate effect. During the course of our investigation, Ms. Human raised further inconsistencies relating to unlawful deductions of medical benefits, African benefits, which is pension benefits, and irregular tax tables used when her benefits were reinstated by SSA. So having analyzed the complaints, we decided to confine our investigation on two issues, whether Mr. Jafta's conduct when he delayed to properly and effectively reinstate Ms. Woman after her appeal was upheld was improper and amounted to maladministration, and whether or not there was unlawful deductions made by SSA when Ms. Harman's benefits were reinstated, and if so, such conduct amounted to maladministration. So as an institution, we found that such conduct was indeed substantiated, and we have made recommendations to SSA, especially because Ms. Harman has already been reinstated in her position, or in the while within SSA, though there are still challenges which position she has been reinstated, and we've advised how the matter should be resolved. The next matter relates to Sonto versus Special Appeals Board of JIPA, where we investigated allegations of improper conduct and maladministration by the Special Pensions Appeals Board with regard to the termination of the special pension of Mr. Mzunani Roseberry Sonto. The investigation was prompted by a complaint Mr. Sonto lodged with the institution in 2019. Mr. Sonto is a pensioner, a former member of the military wing of the African National Congress, Umkhonto Busisiwe, and a former member of the National Assembly who served in the latter capacity from 2010 to 2014. In the main, Mr. Sonto alleged that in 2004 he was awarded a special pension instead of the Special Pensions Act by the Special Pensions Board, and received a pension until it was set aside in July 2017 by the Appeals Board. He lodged an appeal with the Appeals Board in July 2014 for reconsideration of his pensionable years of service, requesting that 7 years of service which had not been taken into account by the Special Pensions Board be added to 5 years of service the board awarded to him in 2004. So he requested that the Appeals Board should recognize and award to him 12 years pensionable service. Instead of doing that, the Appeals Board then decided to terminate or to set aside his appeal, and ended up terminating his whole pension. So he alleged that the board therefore concluded that it was improbable that he was ever restricted or banned or detained or imprisoned. He asserts that in coming to this conclusion, the appeal board had chosen to ignore press photographs, articles from the time describing him as the UDF leader and detainee. Mr. Sonto furnished us with records from the Goodwood Correctional Center indicating that in the 1980s he was arrested for politically motivated offenses. He also submitted articles in the newspapers, Cape Times, by then, around 1980. According to him, although it has a duty to do so, the appeals board fails to question witnesses who would confirm the facts of his service and also declined offers of testimony from those imprisoned with him, such as the former Minister of Finance, Mr. Manuel. He therefore alleged that the decision of the appeal board to cancel his special pension was irrational, arbitrary, unfair as the evidence he submitted to the appeals board refused the basis on which it decided to cancel his special pension. So we found that indeed the decision of the appeals board in setting aside Mr. Sonto's special pension was not in accordance with the relevant law and prescripts. The chairperson of the appeal board ought to have known that in dismissing Mr. Sonto's appeal and setting aside the 2004 award of 5 years pensionable service, Mr. Sonto's vested rights would be adversely affected in that his special pension would be terminated by the Government Pensions Administration Agency. Mr. Sonto was not appealing or disagreeing with the decision of the appeal board, but was merely applying for the extension of his pensionable years of service from 1971 to 1990, whereas the board had decided to award only 5 years pensionable service to him. Accordingly, we then found that these allegations were substantiated. The board acted and prejudiced Mr. Sonto, and we had the following remedial action. The Minister of Finance to take the appropriate steps and against the decision of the appeal board by setting aside the special pensions board's decision award of a special pension for Mr. Sonto, and the Minister of Finance must take this matter on judicial review and to inform Mr. Sonto accordingly within 30 working days, because the board has already decided on the matter and it's only a court of law which can review this decision. So must apologize in writing to Mr. Sonto for the prejudice he suffered as a result of the improper conduct of the appeal board within 60 working days from the date of this report. The next report relates to Mutaung vs. Palchem. We investigated allegations of maladministration, the termination of a contract, and the failure by the state-owned entity Palchem to pay for services rendered by a service provider, Libitso Consulting Services. So Palchem is a wholly owned subsidiary of the South African Nuclear Energy Corporation, NECSA. So NECSA is a PFMA Schedule 2 major public entity. The investigation arose from a complaint lodged in October 2019 by Mr. Mutaung. He lodged the complaint on behalf of LCS. He alleged that Palchem had requested the LCS to assist in sourcing candidates for temporary positions of supply chain manager to be appointed on a 3-month contract. According to Mr. Mutaung, his company submitted the names of the 3 possible candidates to Palchem. Out of the 3, a certain Mr. Mbata emerged as the preferred candidate. Subsequently, Palchem's Human Resource Administrator, Ms. Maluleke, allegedly invited Mr. Mbata to assume duty as supply chain manager on the 21st of June 2019. She allegedly did so through a WhatsApp text message. Subsequently, LCS allegedly entered into a contract with Mr. Mbata to provide supply chain management services at Palchem. So his company sourced him on behalf of Palchem. Further, Ms. Maluleka allegedly requested Mr. Mutaung to draft a contract to be entered into by Palchem and his company. So as Mr. Mbata's agent, Mr. Mutaung drafted and signed the contract. for Mr. Mbata to supply chain management services. So Palchem allegedly did not sign the contract, and yet Ms. Maluleka allegedly sent a WhatsApp message to Mr. Motaung confirming that Mr. Mbata could assume duties. So in this instance, Mr. Mbata assumed duties and started working based on that WhatsApp call or WhatsApp message. So after that, his company submitted invoices to Palchem for services rendered by Mr. Mbata. Despite following up with Palchem employees, Ms. Maluleka, Mkhize, Lungisa Obose, Nontlantla Kumbi, Petros Kete claims of just over 100,000 for services rendered from June 2019 to July 2019 in terms of invoices, which we've mentioned, and an additional 63,000 and 60,000 for August and September 2019, respectively, for services that would have been rendered by had Palchem not improperly or prematurely terminated the contract, which was still outstanding. So in this particular matter, our investigation revealed that indeed Palchem failed to pay for the services rendered, despite the fact that there was no appointment letter or contract entered into between the parties. The evidence in our possession clearly indicate that the company rendered a service to Palchem for a month, and that Palchem was fully aware of the services being rendered during July 2019. In this regard, it can be said that Palchem was improperly enriched through benefiting from the services rendered but which were not paid for. So Mr. Motaung could not have been expected to know whether internal processes at Palchem had been complied with, and as such he rendered services to Palchem in good faith. Section 50 of PFMA, dealing with the fiduciary duties of the accounting authorities, provides that accounting authority for a public entity must exercise the duty of utmost care to ensure reasonable protection of assets and records of the public entity. Accordingly, the former managing director of Palchem, Mr. Mkhwebane, was required to ensure that there was a signed contract between Palchem and Mr. Motaung's company. Such evaluation by Palchem amounts to improper conduct in terms of the Constitution and maladministration in terms of the Public Protector Act. So we've taken the following remedial actions. Within 60 working days of the date of the formal report, effect payment to LCS for services rendered to Palchem in accordance with invoices which were submitted, and within 60 working days of the date of the formal report, investigate and take appropriate steps in respect of disciplinary action against officials of the entity, particular Ms. Maluleka in terms of the PFMA for advising the LCS to commence with work at Palchem before the managing director had signed the appointment letter and contract in order to comply with the supply chain management policy. Within 60 working days after date of this formal report, ensure that all officials are trained in terms of the Palchem supply chain management procurement processes, contract management, and delegation of powers in accordance with PFMA. Within 60 working days after the date of this formal report, review the practice of allowing staff to use their personal laptops, should this practice still persist, and put measures in place to procure resources for staff in terms of the PFMA. Within 60 working days of the date of this report, review and approve and roll out the information and communication technology and security policies to prohibit unauthorized use or access to undesignated persons to mitigate the risk associated with exposure of Palchem to unauthorized persons. Ensure that Palchem's internal audit unit on an annual basis reviews the adequacy and effectiveness of the Palchem system of internal control, risk management, and supply chain management in terms of the PFMA. Further, we directed the chairperson of the board of Palchem to, within 30 working days of the date of this report, submit an implementation plan of the remedial action contained in the formal report. The next report we investigated, in fact, it was an anonymous complaint, since people are allowed to lodge anonymous complaint. against any state institution. It's Anonymous versus Nkonyeni, the former MEC of Human Settlements and Public Works in KwaZulu-Natal. Apparently that Ms. Nkonyeni failed to comply with the provisions of the Rental Housing Act 1999 in the appointment of the members of the KwaZulu-Natal Rental Housing Tribunal. The investigation stemmed from an anonymous complaint lodged in January 2021, wherein it was alleged that the appointment of the members of the tribunal were irregular as advertised for the positions. And it was also alleged that the appointees were all lawyers and that the former MEC failed to consult with the KZN Portfolio Committee on Human Settlements before the appointments were made, as the Act requires. Having studied the complaint, we decided to focus the investigation on whether the former MEC failed to comply with the requirements of the Act when appointing the members of the tribunal, and if yes, whether such conduct of the former MEC was improper and constitute maladministration. We found that indeed the former MEC failed to comply with the relevant provisions of the Act when she appointed the tribunal in December 2020. The composition of the tribunal does not include sufficient expertise in rental housing matters or property management or housing development matters or consumer matters pertaining to rental housing or housing development matters as provided for in terms of Section 9, subsection 1 and subsection B of the Act, which that's a requirement for that. The former MEC also did not consult with the Portfolio Committee before appointing the tribunal, as Section 9, subsection 2B of the Rental Housing Act requires. The section provides that the chairperson and members of the tribunal must be appointed only after the MEC has consulted with the relevant standing or portfolio committee of the provincial legislature, which is responsible for housing matters in the province. So according to the chairperson of the portfolio committee, the committee was not advised in advance on the processes leading to the appointment of the tribunal. The chairperson further stated that the committee as a collective was not favored with the advertisement for the tribunal and nomination process thereof, and that the committee did not comment on the advertisement or whether it complies with the Act. The chairperson also indicated that the former MEC first mentioned the tribunal to the committee in January 2021 during a meeting. The chairperson considered that the investigation that the appointment of the tribunal was not in full compliance with the requirements of the Act, and further that the committee did not participate in any way in this process, save to meet the tribunal after its appointment. Instead, the former MEC took the matter to the Provincial Executive Committee that did not consult in regard thereto, but simply appointed the nominees as the tribunal. The former MEC's conduct was accordingly at variance with the provisions of the Act, and therefore constituted improper conduct as envisaged in the Constitution and maladministration as envisaged in the Public Protector Act. The tribunal's appointment is an administrative action. The fact that its appointment was not in accordance with the Act does not mean that it can simply be ignored. In the case of Oudekral Estate versus the City of Cape Town, the Supreme Court of Appeal authoritatively ruled that until an administrative action is set aside by a court in the proceedings for judicial review, it exists in fact and it has legal consequences that cannot simply be overlooked. So the principle enunciated in the Oudekral case was confirmed by the Constitutional Court in the case of the MEC of Health, Eastern Cape versus Geland Investments. That court was called upon to reconsider the correctness of the principle in Oudekral. So the court rejected this invitation and found that if public officials or administrator can, without recourse to legal proceedings, be allowed to disregard administrative actions by their peers, subordinates, or superiors if they consider them mistaken, this would be a license to self-help. It would be inviting officials to take the law into their own hands by ignoring administrative conduct they consider incorrect. So the court found that this would spawn confusion and conflict to the detriment of the administration and public. Consequently, it is not open to the current MEC and the department to simply ignore the appointment of the current tribunal and to appoint another. A proper judicial review application has to be brought to firstly review the appointment and for the court to make an order that is just and equitable under the circumstances when the tribunal that consists of members that were irregularly appointed has already taken several decisions as the tribunal has legal consequences. To remedy this improper conduct and maladministration, the MEC for Human Settlements and Public Works must lodge a judicial review application for the review and setting aside of the appointment of the tribunal as per the Audegral case above within 90 working days from the date of this report. The MEC must also report to the Premier and Speaker of KwaZulu-Natal Legislature on the implementation of the remedial action taken above within 120 working days from date of the report. The Premier of KZN as the head of the Provincial Executive Council, who appoints and assigns functions to ministers, to MECs, should oversee the implementation of the report as per Section 132 of the Constitution and in compliance with Section 136 of the Constitution, which requires MECs not to act in any way inconsistent with their office. The Premier must within 60 working days from date of this report submit a plan of action to us on measures to ensure that there is continuous training, workshop programs for MECs about their responsibilities, to ensure that administrative actions taken are in accordance with the provisions as provided by or prescribed by national legislation. The next matter relates to Wilkinson versus the City of Johannesburg. This is a whistleblower-related matter. We investigated allegations of occupational detriment and victimization of whistleblower, the late Ms. Lorraine Wilkinson, leading to her dismissal by the City of Johannesburg. This followed a complaint lodged in October 2019. Ms. Wilkinson, who has since passed away, joined the COJ External Relations Division in 2005 after serving 25 years at the national and local spheres of government. At the time of her dismissal, she was within the Group Risk and Assurance Service as Unit Head of Strategic Management Services. Her responsibilities were advisory, and she was also responsible for finance, business planning, and performance management and administration. In her complaint, she alleged that during 2014, a number of administrative irregularities within the City of Johannesburg came to her attention. One of those was the then city manager, Mr. Trevor Fowler's extension of the employment contract for the group head, Ms. Nxumalo. During September 2015, Ms. Wilkinson allegedly handed a whistleblowing dossier and a group grievance which she had also signed to the former executive mayor, Palchem. These were allegedly also submitted to Mr. Fowler through the South African Municipal Workers and Allied Union. Whilst Mr. Tau was attending to the disclosure, he was removed from his position as the executive mayor as a result of the local government elections that took place in 2016. So the disclosure file subsequently found its way to the newly elected administration under the leadership of the former executive mayor, Herman Mashaba, who directed that a forensic investigation be conducted on the irregularities Ms. Wilkinson reported. A forensic company, KPMG, was assigned to conduct the investigation, and one of the recommendations highlighted in the KPMG report was the protection of whistleblowers. When both protected disclosure documents came to the attention of Ms. Nxumalo, she allegedly called Ms. Wilkinson and threatened her with investigation. Ms. Wilkinson alleged that Ms. Nxumalo victimized, intimidated, and harassed her. In addition, Ms. Wilkinson alleged that she was suspended, investigated, and dismissed on trumped-up charges. She then referred her dismissal to the South African Local Government Bargaining Council for arbitration in 2016. During the course of the arbitration in 2018, the Office of the City Manager and Labor Relations directed that the process should end as they had prepared a settlement with her. However, nothing came of this as the draft settlement was not signed. Further, Ms. Wilkinson alleged that she suffered occupational detriment as the result of undue delay to finalize the proposed settlement. She suffered severe financial difficulties in that she lost her house, her child dropped out of school, There were no funds for basic necessities, and her health was deteriorating. After a thorough analysis of the complaint, we decided to investigate whether the city delayed or failed to act in line with the Protected Disclosures Act as amended, following a protected disclosure Ms. Wilkinson made, causing her to suffer prejudice. We found that the city acted improperly when it failed to protect Ms. Wilkinson in terms of the PDA, thereby causing her to suffer prejudice. The disciplinary action against her was initiated by Ms. Nxumalo, whose contract with the COJ at the time was unlawfully and irregularly extended by the former city manager, Mr. Fowler, without consultation with the city council, as required by Section 56A of the Municipal Systems Act. Consequently, it can be concluded that all further actions or decisions taken by the COJ with regard to Ms. Wilkinson's disciplinary process, as initiated by Ms. Nxumalo, should be regarded as null and void in law. The disciplinary action was initiated by Ms. Nxumalo and pursued by the city as a result of the protected disclosure by Ms. Wilkinson in terms of the Protected Disclosures Act, which disclosures by their nature and indeed under these specific circumstances ought to have triggered the COJ into affording her adequate protection from occupational detriment, amongst others. The evidence received during the investigation indicates that Ms. Wilkinson had made the disclosure in terms of Section 9 of the PDA, which is deemed for the purpose of the Act to be a protected disclosure, as she made it in good faith. In the circumstances, we find that the disclosure by Ms. Wilkinson was indeed qualifying to be regarded as such. So following the protected disclosure, Ms. Wilkinson indeed was subjected to that disciplinary hearing, which prejudiced her. And in addition, the arbitrator, Mr. Timothy Boyce, had already noted that in terms of Section 187(1) of the Labor Relations Act, as amended, that the dismissal was automatically unfair if the reason for the dismissal was the employer's contravention of the Protected Disclosure Act on account of an employee having made a protected disclosure as defined in that act. Ms. Wilkinson consequently suffered occupational detriment and remained unemployed up to the time of her demise in 2021, whilst under severe financial distress as a result of her dismissal. The conduct of the city in this regard is therefore improper and constitute improper conduct as envisaged in terms of the Constitution, and maladministration as envisaged in the Public Protector Act. To remedy the situation, we are finding that, or we are directing the following remedial actions to the municipal manager. Must take cognizance of this report insofar as the improper conduct by COJ, as highlighted in the findings referred to above, is concerned. In line with the principle 7 of the Batupili Principles, issue a written apology posthumously to Ms. Wilkinson's family, in particular to her son, for the immense harm and prejudice caused to them as a result of the inaction in effectively addressing this issue within 30 days of issuing this report. Consider taking appropriate steps through which Ms. Wilkinson's estate can be compensated in terms of Section 193(1)(c) of the LRA, since it is no longer practical for the COJ to reinstate or re-employ Ms. Wilkinson as she is deceased, and do so within 60 working days of issuing of this report. The compensation to be awarded to Ms. Wilkinson must be calculated in line with the provisions of Section 194(3) of the LRA, which must be just and equitable in all circumstances, but not more than the equivalent of 24 months remuneration calculated at Ms. Wilkinson's rate of remuneration on the date of dismissal. Within 30 working days of issuing this report, if not in place, consider and approve a whistleblower blowing a policy for the COJ on which all employees must be trained and be made familiar with and present to EXCO and Audit Committee for consideration on a quarterly basis the whistleblowing report within the compliance universe of the city. The next report relates to Limpopo Department of Health, and this was an own initiative investigation relating to procurement irregularities and nepotism in the awarding of tenders for the supply and delivery of personal protective equipment. A Sunday Independent newspaper article headlined at 932 million PPE mess triggered the investigation. So the article contained the following allegations. Some of the companies which were awarded the PPE tenders were handpicked and did not appear on the official database of the department. Suppliers, the companies awarded the tender are owned by people who are politically connected. The companies appointed and awarded tenders belong to the ANC activists and relatives of senior officials, including prominent politicians. The department's officials manipulated the procurement processes to benefit their associates and close comrades before locking away all PPE documents. Having analyzed the allegations thoroughly, we decided to investigate the following three issues: whether the department followed the due process in the procurement of PPEs, whether there was nepotism or undue influence, favoritism in the appointment of service providers, if yes, whether other prospective service providers suffered prejudice as a result. We found that indeed the department did not follow due process in the procurement of PPEs. The department procured the supply and delivery of PPEs through an emergency procurement process provided in the National Treasury Practice Notice or Notes. The deviation was executed in terms of paragraph 14.2.5 of the department's supply chain management procurement policy, which provides for the exemption or deviation from the normal bid procedures as necessitated by the emergency of the COVID-19 pandemic. According to evidence obtained, the deviation was reported within 10 working days to the Provincial Treasury and to the Auditor General on in June 2020 and 14 July 2020. The department, the head of department complied with the provisions of the practice notes by reporting the deviation to the Treasury and to the AGSA within the prescribed period. We could not find evidence indicating that the department did not follow their SCM policies, which also regulates the deviations, and they've complied to that. So evidence was, however, uncovered to prove that the department did not comply with the National Treasury SCM Instruction Note 9. So there's another instruction note which they never complied with, relating to the procurement of PPEs by appointing service providers. So though the Mkhwebane Training and Consulting was awarded the PPE tender, the HOD confirmed that the company did not render services and as such was not paid. And the director of Mkhwebane and Consulting also confirmed that, and the evidence before us confirms that. Similarly, Machawana Trading was awarded the tender. The HOD confirmed that the company did not render services and as such was not paid. And the director of Machawana also confirmed that his company did not render services as the order was cancelled because the service provider could not deliver services at the required time. Sedilaka Holdings and projects as well as Opane Farm Group supplied and delivered the PPEs and were paid for services rendered, but did not claim VAT. The conduct of HRD is in contravention of the, is in contravention of Section 38(1)A by failing to ensure that there was an appropriate procurement and provisioning system which is fair, equitable, transparent, competitive, and cost-effective, by failing to prevent unauthorized, irregular, and fruitless expenditure. And the conduct of the HOD constitute maladministration and improper conduct. We found that the allegation that there was nepotism or undue delay, favoritism in the appointment of the service providers for the provision of the PPEs is unsubstantiated. We found indeed that there is evidence which proves that the contracts awarded to the two companies, Mkhwebane and Machawane, were awarded, but the orders were cancelled. And independently obtained evidence confirmed that the directors of the following companies, Ndia Business Trading, Luhura Trading and General Supplier, Mkhwebane Training, are politically connected or related to senior officials in government. But we could not find any evidence that confirms that there was nepotism or undue influence by those politicians. The HOD did not deny the relationship between the director of NDIA or Ndia Business Trading and the deputy chairperson of the ANC, Ms. Razilani. Luhuri Trading and General Supply and Deputy Director General for Institutional Support in the Premier's Office, Mr. Managa, as well as the relationship between the Director of Mkhwebane Training and Consulting and the former MEC of Department of Sports, Arts and Culture, Ms. Onika Mkhwebane Muloi. However, she denied any relationship between the company directors and the members of the PAC and, in fact, bid evaluation committee and bid adjudication committee, which could have influenced the procurement process within the department. We could not find any evidence indicating that the MEC and the HOD had any influence in the awarding of the PPA tenders, even though there is evidence that indicates that some of the service providers are related to the politicians concerned and the senior officials concerned. We could not find evidence to prove that alleged possible influence in the procurement processes. So the conduct of the department neither constituted maladministration or improper conduct. So this is the second issue of the relationship, which is not substantiated. So on the issue which is substantiated, in fact, earlier we said they've reported to National Treasury, but then there was where they did not report on time. In fact, the first procurement they reported to Treasury and AG. The second procurement they reported to Provincial Treasury, but not to AG. So to remedy that issue, we then had a finding where we request the HOD must, within 60 working days of receipt of this report, take appropriate disciplinary action against the SMM officials who were involved in the procurement for failure to comply to the second deviation. And then within 120 working days of receipt of this report, and upon discovery of any unauthorized, irregular, and wasteful expenditure, immediately report in writing particulars of the expenditure to the relevant treasury, and in the case of irregular expenditure involving the procurement of goods and services in terms of the PFMA. Ensure that the internal audit unit on an annual basis reviews the adequacy and effectiveness of the department's system of internal control, risk management, and SAM, and ensure that the audit committee of the department in all its meetings consider the internal audit and AGSA reports to ensure that the recommendations are implemented. The acting HOD must, in terms of paragraph 17.1.2 of the SAM policy, report any criminal conduct to SAPS. Within 90 working days of the date of this report, refer the matter to DPCI and Asset Forfeiture Unit in terms of the Public Protector Act. So we are referring this to those units. Actually, we will refer this to the DPCI ourselves, not through the HOD. I hope you note that, CEO. So lastly, the AGSA must take note of the findings relating to the improper conduct and or maladministration reported therein. The last report relates to Manyi versus South African Revenue Service. We investigated allegations of maladministration, improper conduct, and procurement irregularities by the South African Revenue Services, SARS. A complaint lodged in October 2016 by Mr. Manyi led to this investigation, who alleged that in or about 2006, the erstwhile Commissioner of SARS, Mr. Godan, submitted a memorandum to the then Minister of Finance, Mr. Trevor Manuel, recommending the noting of an intended appointment of Baj, Baron, and Dominic, which is BBNT, to replace Sibel, known as Oracle, and IBM as the new service provider for the provision of strategic projects and related services within SARS modernization program. The memorandum was sent in light of the intended cancellation of the appointed service provider, Oracle, which in December 2005 entered into an agreement with SARS to provide software licenses, maintenance, as well as professional services to configure and co-develop functionalities to meet SARS customer management needs. The then Deputy Minister, Mr. Muleketi, noted the memorandum and requested more information, but Manuel went beyond noting and approved the memorandum. The contract was for 100 million and no tender process was followed in the appointment. So those are the allegations. SARS contravened Treasury Regulation 16A 6.4 in that the institution had no solid ground to deviate from normal competitive bidding. The appointed service provider had 4 weeks to make proposals to SARS. The appointed service provider had 6 weeks to scope the project, which was awarded already. And the appointed service provider rescooped the awarded contract. The 10 weeks mentioned above could have been used to facilitate and solicit public competitive bidding. The 100 million tender awarded has now escalated to over 1.4 billion. And SARS appointed BBNT on the basis that Mr. Barry Hall, the then General Manager Strategy, Modernization and Technology, recommended the service provider as he had previous dealings with them. Having studied the complaint thoroughly, we decided to restrict the investigation to the following 2 issues: whether SARS irregularly appointed BBNT in 2007 for the provision of strategic projects and related services without following proper procurement processes, and if so, whether such conduct amounts to maladministration and improper conduct in terms of the Protector Act and improper conduct in terms of the Constitution and maladministration in terms of the Constitution. Whether SARS subsequently continued to irregularly extend the same contract with BBNT, and if so, whether such conduct amounts to maladministration and improper conduct in terms of the Public Protector Act and the Constitution. At the outset, I wish to indicate that our jurisdiction to investigate this matter, which originated more than 2 years before the complaint was lodged, was specifically challenged by some of the parties involved in the investigation. In terms of Section 6, subsection 9 of the Public Protector Act, except in special circumstances within our discretion, a complaint or matter referred to us shall not be entertained unless it is reported to us within 2 years from the date of the occurrence of the incident or matter concerned. We carefully considered all the submissions made in this regard and exercised our discretion, mindful of the jurisprudence addressing this matter and all relevant factors pertaining to the allegations, its impact on the public interest and the interest of justice. Having considered also the large amounts of public money involved and the public importance of proper conduct and administration by SARS, which is a custodian of public money that is supposed to be an example to other organs of state in the administration thereof, we decided that sufficient special circumstances existed to warrant an investigation of the complaints that were lodged. This aspect is discussed in detail in the report. So on the first issue, we found that SARS irregularly appointed BBNT for the provision of strategic projects and related services without following proper procurement processes. From the evidence submitted, SARS did not conduct a needs assessment as required by National Treasury Regulation 16A 6.3 and paragraph 3.1 of the Supply Chain Management Guidelines for Accounting Officers. The product that was required when the request for tender was issued was amended after SARS had already entered into an agreement with CBEL in December 2005. Although when SARS first appointed BBNT for its modernization program, the institution resorted to the provisions of Regulation 16A6.4, which provides for deviation from normal procurement processes without the need to follow an open and competitive process as required by Section 217 of the Constitution and Treasury Regulation 16A3.2. We could not find compelling reasons for them to do so. The reasons recorded and approved by the accounting officer were self-created by SARS, in that they had been informed by CBEL that they would not be able to meet the requirements that SARS had wanted. However, SARS waited until the last minute to identify the need for a new service provider, having also amended the scope of the initial tender. The awarding of the contract to BBNT was in violation of the provisions of Section 217, subsection 1 of the Constitution, read with Treasury Regulation 16A3.2, A, regarding fair, equitable, transparent, and cost-effective procurement process applicable when a state organ contracts for goods or services. This was also in conflict with Section 195 of the Constitution, which provides that the public administration must be governed by the democratic values and principles, inter alia, that a high standard of professional ethics must be maintained and public administration must be accountable, as SARS senior officials did not adhere to this ethos. The conduct of Mr. Godan as the then Commissioner of SARS and Accounting Officer in approving the appointment of BBNT constitute improper conduct as envisaged in the Constitution and maladministration as envisaged in the Public Protector Act. Regarding the second issue, we found that SARS continued to irregularly extend the same contract with BBNT by continuing to extend the contract over a period of time exceeding 10 years, using numerous deviations approved by SARS Executive Committee and without resorting to an open tender process, and instead utilizing procurement exemptions approvals in terms of the Treasury regulations, which SARS seems to have created for its purpose and used continuously for its subsequent requests for extension approvals. The process followed by SARS not only flouted the National Treasury regulations and practice notes, but was also not fair, equitable, transparent, competitive, and cost-effective in line with Section 217(1) of the Constitution. After making an undertaking to us to end the contract by December 2019, SARS reneged on their commitment by requesting a further and even longer extension from National Treasury until December 2022. This seems to suggest that SARS was not keen on ever terminating this contract at any point. I must indicate that from the evidence provided, only the National Treasury and not the Auditor General South Africa was informed of the exemption requested and approval. However, National Treasury continuously cautioned SARS against flouting the provisions of Section 217 and tried to approve shorter periods of extensions, on which SARS always challenged National Treasury until they got what they wanted, namely a further extension to December 2022. The conduct of both the erstwhile and current accounting officers of SARS with regards to the extensions is therefore in violation of Section 51, subsection 1A, Roman figure 1 and 3 and 4 of the PFMA, which provides that the accounting officer for a department, trading entity, or constitutional institution must ensure that such trading entity maintains an effective, efficient, and transparent system of financial and risk management and internal controls, whilst also ensuring to have in place an appropriate procurement and provisioning system which is fair, equitable, transparent, competitive, and cost-effective, as well as a system for properly evaluating all major capital projects prior to a final decision on the project. The conduct of the then commissioners, Mr. Oupa Magashula, Mr. Tom Moyane, and later Mr. Edward Gesveta, in the continued extension of the BBNT contract against our directive and the National Treasury's advice, amounts to improper conduct as envisaged in the Constitution and maladministration as envisaged in the Public Protector Act. To remedy this improper conduct and maladministration, we direct the Minister of Finance to take cognizance of the findings of the maladministration and improper conduct in this investigation against SARS and include this in his oversight role over SARS, the monitoring of implementation of remedial action taken in pursuit of the findings in terms of the powers conferred under the Constitution. The Director General of National Treasury must take cognizance of the findings and challenges identified in this investigation in as far as they relate to National Treasury's involvement in the approval of continuous deviations and granting of extensions to BBNT contract in terms of Treasury Regulations 16A6.4. In line with Section 195 of the Constitution, to develop a policy on the management of IT constructs by state institutions that diverges from abuse of National Treasury Regulations 16A6.4, which ostensibly encourages the deviation from a competitive process, bidding process. The Commissioner of SARS must take cognizance of the findings of maladministration and proper conduct and ensure that, in line with Section 51(1)(a) of PFMA, an agent review of the contract between SARS and BBNT is undertaken to ensure that SARS is able to continue with the modernization program without a single company controlling the functioning and implementation of the program. In line with Section 217(1) of the Constitution and Treasury Regulations 16A3.2, within 180 days of receipt of this report, a competitive tender process is undertaken with a view of appointing a new service provider prior to the expiry of the current contract on 31 December 2022. In line with Section 51(1)(a) of the PFMA, the intellectual property of SARS is protected and that services relating to the system provided by BBNT are not interrupted in the transition period, and no further extension of the BBNT contract upon request by the accounting officer are approved by National Treasury beyond December 2022. The Auditor General South Africa must take note of the findings relating to the maladministration and improper conduct identified in this investigation made against SARS, and within its own discretion consider the findings and remedial action in this investigation and consider taking any action deemed appropriate under the circumstances in terms of any applicable legislation. Further, the National Head of Directorate for Priority Crimes Investigation must take cognizance of the investigation and findings made in the report, and in terms of Section 80 of the PFMA, consider investigating possible criminal conduct by the relevant accounting officers of SARS. We look forward to the implementation of the remedial action in respect of all the above reports. We remain available to offer guidance in case of challenges with implementation. The aim is to do our bit in respect of strengthening governance and improving the quality of public service rendered to the public. In addition, we seek to ensure accountability in all state affairs while stemming impunity. On the issue of Abraham J. and the Constitutional Court, as I draw to the conclusion, I wish to express myself on a matter that is in the public domain and is unrelated to our investigation report. I welcome the statement made by the Chief Justice on SABC TV last night that the issue of the person who sent a message regarding a decision of the Constitutional Court which has not yet been announced is unacceptable and is being investigated. Chief Justice has acknowledged receipt of the letter we've sent to him on Tuesday, 26 April 2022, on behalf of all the parties in the postponed application before the Western Cape High Court. He has assured us that the matter is being investigated. So further, I'm seeking legal advice on the question of laying criminal charges against the sender of the SMS in question, Mr. Ismail Abramji, and his accomplices for confidential message based on very good authority that an unusual decision has already been made to dismiss my rescission application without a hearing or even answering affidavits having been filed. After the outcome of the investigation has been released, I await the directions of the CJ in terms of the relevant rules of the Constitutional Court. Thank you so much for your time.
Thank you, Public Protector. I will now invite the colleagues in the room and those joining us virtually to indicate if they have got any questions for the Public Protector before we adjourn the media briefing. Let me see by a show of hands who in the House would like to pose a question or two to the Public Protector. I note Mr. Imelusuki from ENCA. In the absence of any other, you may go ahead, Mr. Lusuki.
DP Treaty Jones, ENCA. Just wanted clarity around the issue of the money versus SARS matter. Does this, am I stand to be corrected, do we then say that all commissioners are, implicated in this whole proceeding that took place? Because it seems as though, yes, the then Commissioner, Mr. Prabhu Gordon, did not pay proper oversight to the contract, while we're also seeing other commissioners as well do not put an end to the extension of the contract, but do not flag it, while knowing that the company does not meet the correct PFMA procedures. And two, are you aware that there could be more legal action taken against this report in regards to taking on judicial review? We've seen other cases whereby one of the members implicated in the report has challenged the report as well and taken them upon review. And maybe the last one, if you could just clarity on the last section where you speak about Mr. Ismail Abramji. Do you think that this is a concern? We've seen that there's also been reports around what one would dub as judicial capture. Do you think that this is a problem, that such pivotal information is being shared while such sensitive proceedings are underway regarding your future and office as well? Thank you very much.
Thank you, Mr. Lusuki.
Thanks for those questions. I don't know whether to say thanks for those questions. Yes, clarity on the issue of the money versus SARS. Indeed, all the commissioners, they've neglected their responsibilities in terms of the PFMA. I mean, they were expected to make sure that the process is stopped of continuously extending that particular contract. I must indicate that in the report, we are mentioning that during the acting SARS Commissioner, Mr. King Mark, where we requested them to stop these extensions until December 2019. Indeed, that was done, and they advertised the tender. But then when the tender was advertised, apparently there were challenges, or it was challenged. And then after that, the current commissioner never then proceeded to make sure that anything is corrected and the matter is dealt with. So all the commissioners, indeed, because we deal with what the law is saying here as the public protector. We are not, we check the conduct against what the relevant prescripts are saying. So PFMA requires accounting officers to act in a particular way, and even to make sure that they are not violating even the Constitution, because the issues of procurement are from the Constitution, Section 217, and we have then the legislation dealing with that, or empowering legislation. So indeed, are we aware that we will be taken on review? You know, the Constitution and the fathers of the draft, or the drafters of the Constitution, when they were saying the public protector and even the Chapter 9 institution must do their work without fear or favor. I know, yes, a number of times there are a lot of attempts where we are threatened that we will be taken on review. Even during the investigation, it's very difficult engaging the institutions and showing them that this is our focus and why we are saying this matter is substantiated and it should be corrected. And I think I will go further than that. I'll ask the CEO to also add, where actually being a person who just joined the institution and you then receive responses even from the ministers, and they don't also seem to be seeing that, we would want them to make sure that in whatever they are doing, they are compliant to the Constitution, they are compliant to the law as it stands, because you cannot run institutions as if you are running your own company or even your own home. So there are laws which they need to comply with. And indeed, they are free to take us on review. Remember, we've been always, we've been saying that after the 2016 judgment of, well, the so-called Kandla judgment, where our remedial actions are binding unless set aside by a court, they can take us on review. They are free to do that. And we've tried our level best. We have all the evidence. And again, it's up to the courts to decide whether they would want to see SARS, an institution which is reputable, to always continue extending the contracts. Then it means all institutions can do as they please, irrespective of what the law is saying. Ishmael Abraham Jemeta, indeed this, you know, the former Chief Justice once said people must come forward if they have any evidence or information about the alleged judicial capture, and even the current Chief Justice. So it's concerning that, I mean, such information comes to the fore, and I think, you know, we would say, or I would say, the Advocate Brettenbach SC, we need those caliber of people in our legal profession who would assist and make sure that we don't have such instances where, you know, court cases, I mean, we go, our legal teams prepare, you know, read up to 6,000 pages preparing to argue matters, and then at the end of the day there's some choreographed process where people know the outcome of the court cases. So I think investigating this matter and going deeper to the root causes will help, and we are looking forward to the outcome of the investigation by the Chief Justice, because they've responded and they've said they will be, they are in the process, they will investigate the matter. So we are looking forward to the outcome of that matter.
Thank you, Public Protector. Are there any further questions? Oh,
just one more Public Protector for clarity. I mean, you say that you look forward to Chief Justice urgent response to the letter sent to him on Tuesday on behalf of the parties and the postpone application. What do you think, or what do you preempt of the outcome? Are you positive that the outcome might go in your favor in terms of what you've justified as having to be resident in office as well and carrying out your work duty?
You know, I'm positive, or we are positive, that the Chief Justice, for the sake and the integrity of the judiciary, they will conduct a thorough investigation, and I'm hopeful that they will have an outcome which will stop this, you know, what we call suspected judicial capture. So I think it's up to him to make sure that there's integrity in the system, and for the public to trust the judiciary again, because such incidences are very concerning.
Thank you, Public Protector. Are there any further questions? In the absence of questions, I will proceed to adjourn the briefing. Thank you so much for coming through. All of the reports that the Public Protector has released this afternoon will be accessible on our website, and those of you who are part of our WhatsApp group will access them on that platform. Thank you.
Thank you. Thank you. Thank you, CEO. CSNE. This means China City CSNE. What? CSNE. Not really. Well, maybe my son and the wife. Okay, thanks. Asematheni in ngibonile kufuneka futhi.
Abana corrective statement or corrective
Limpopo Municipality.
Yeah. Okay, sure, thank you. Are they not in the list?
No, they say they're fine.
Oh, because they think they're busy looking at me. Court, how are you? Gumbi is here. Gumbi is here. I want us to talk about that thing. Because how do we deal with this now? Sure, I can have so many documents. I can't find my Donga must go to the office. I'm waiting for you, boys. Boys. All right, Thank you so much. Okay.